Hi, I'm Rolf Kurtajka with Brightwood Real Estate Education. Let's talk about water rights. Now, we're going to take a generic look at water rights. Whatever state you're living in, those states often have very unique or different types of water rights. I live in Minnesota. We have lots of water. We have lots of shoreline issues here. In arid states, it's not so much shoreline issues. It might be more about water use. So whether you have rights, like anglers have right of access to water, a lot of that's going to be determined by your state laws. So make sure you're aware of those issues wherever you're going to be operating. But let's take a look at water rights from the view from 30,000 feet. So we have two different groups of water rights. We've got a property owner's water rights as it pertains to the shoreline or the shoreline water rights. That's when the landowner has land abutting a water source. Then we've got the right to use water when you're not right next to that water. All right, we're talking about land used for irrigation or consumption in a subdivision, and the water source is way far away somewhere, maybe up in the mountains. First, shoreline water rights. And the type of rights that you're talking about or the type of rights you have may depend on whether the water is standing water or flowing water. So water rights as they pertain to flowing water are known as riparian. That's when you own land adjacent to flowing water. So think riparian, river, riparian rights. Versus littoral. Littoral rights, water rights or shoreline rights, pertain to if I own land adjacent to standing water. So think littoral, lake, littoral rights. Ownership rights, generally, when we're talking about shoreline rights, riparian rights or littoral rights, shoreline or river on a lake, my rights generally extend to the average or the mean high water mark. Now, different states will define this different ways, but usually it's pertaining to a certain type of soil, a certain types of plant that exist in that zone where water meets shoreline. Again, other states might have different ways of defining it, but in general, your ownership rights end at the mean or average high water mark. Also, water rights are often tied to the navigation rights, or is the water body a navigable waterway? You're not going to be able, if you live on the St. Lawrence Seaway, you can't build a causeway out across the river. You can't impede with the navigation. Likewise, if you're on a lakefront, you can't build a dock beyond what the law permits because boats and stuff are going to have free access to that water. You can't impede that right of navigation. So whether it's shoreline on rivers or shorelines on lakes, it's often tied to navigation rights. Then we've got the water use rights. The right to use water for, say, irrigation does not automatically include the right of access to the water source. In fact, in arid states, it rarely does. Usually you have supply pipes or irrigation channels or irrigation ditches that distribute water from the source for water use. So it's not shoreline abutment, it's the right to use water. Now in arid states, you might hear the term prior appropriation. Water rights may be determined by the doctrine of prior appropriation, especially in arid states. Now in this case, prior appropriation means the water rights are determined by state law. The water rights aren't determined by the landowner adjacent to the water. Now we're going to have another video that's just about prior appropriation. All right? But for now, that wraps up our conversation on water rights. We've got shoreline rights and right to use.